Are alimony or child support payments tax deductible? Hi, I'm Bill Farias, founder of Farias Family Law. We met with a woman a couple of weeks ago. She's moving toward divorce and she's looking at potentially having to pay child support and alimony. And she wants to know if either of these payments will be tax deductible for her moving forward. For child support, the answer is easy. Child support is not tax deductible and is not treated as income for tax purposes. It hasn't been as long as I can remember. It isn't now, so we can put that aside. For alimony, it's a little bit more complex. Up until the end of 2018, alimony payments were tax deductible, and alimony was treated as income for tax purposes. However, a new tax law went into effect on January 1st, 2019, and essentially what it says is that alimony payments are not tax deductible and are not treated as income on the federal level for tax purposes. So no federal deduction or income treatment for alimony, and that is relevant to any agreement that is finalized or any judgment that is entered on a divorce case involving an issue of alimony on January 1st, 2019 or later. So if the case was finalized January 2019 or later, this tax law is in effect, and alimony is not tax deductible and is not treated as income for federal tax purposes. However, it can still be treated as income for state tax purposes, depending on your state. We're here in Massachusetts. It is treated as income and it is deductible for state tax purposes. You would have to check, depending on the state that you live in, whether that applies in your state. The other thing to remember here is also that if the judgment was entered before 2019, so December 31st, 2018 or before, and you are modifying an alimony provision and the terms are changed after January 1st, 2019 or later, then this tax law also applies to the modification. And so the way that it's a little bit different is that as part of the modification, the judge or the parties have to explicitly put in the agreement that alimony is no longer tax deductible and no longer taxable if they want to go that route. So if there isn't any language on the new modification judgment, then it stays the same and alimony remains tax deductible and taxable. If either the judge decides or the parties decide they want to change that, they have to make it clear in the modification agreement. So is child support taxable or tax deductible? No. Is alimony taxable or tax deductible? No, it isn't for judgments entered January 1st, 2019 or later, and for any modifications that are completed January 1st, 2019 or later, as long as the language in the judgment or in the agreement make it clear that the parties no longer want alimony to be taxable or tax deductible. If you have any other questions about this, you can call us 508-675-0464. You can email us at info@fariasfamilylaw.com. If you found this video helpful, you can subscribe to our channel, share it with anyone you think might benefit from it, and you can find us on social at Farias Family Law. Thank you. Have a good day.